welcome to tonight's webinar. My name is Michael Clark, sitting here with Eric Boughman, talking all about tips for protecting and preserving your money. Whether you've been to one of our workshops before, Eric and I have presented at a couple of them. Perhaps you're part of the Winter Park Library and you're a patron and they invited you. Just know that I'm certainly glad you are here. I sit on the Advent Health Cancer Board with Eric. We've had a great partnership in terms of doing these workshops professionally, just because we have such a cohesive practice areas in terms of me doing the investments and then him on the legal side. I'm going to give a quick update on where we are in terms of the stock market and give you a couple tips and tricks when it comes to preserving and maintaining your wealth. And then we'll bring Eric up in just a little bit too, and he'll talk about the legal side of what we're discussing this evening. As I like to start every workshop with, I like to kind of describe where we are in the stock market and the economy. So I have a couple slides on that. Now, if you've been paying attention, if you've turned on the news, maybe you've looked at your recent investment statement, chances are it's up. The stock market, and this is the S&P 500, which is the 500 biggest stocks in the United States, it gained 5.3% last month in April, which makes the stock market, again, measured by the S&P 500, up 11.8%. So all in all, when you look at stocks or when you look at taking risk with your investments, the general stock market is up just under 12% so far, and we're only through about 4 months of the year. So things are going well when you look at stocks. Now, things can be a little mixed on the more conservative side. So if you have bonds, if you have CDs, if you have other items that are in lower interest rate type vehicles, some of those aren't doing as well. The stock market certainly has gotten the press as of late because it is doing really well. Where some of those other conservative investments, it can be kind of a mixed bag. So it really depends on what you are investing in. Money market, short-term bonds, those haven't really been paying all that much because we are in a very low interest rate environment where some of the structured products, some of the more unique conservative investments have been doing a little bit better as of late. Speaking of money in the sideline, this is a little bit of a technical slide, but this just shows the change in how much money is set aside in savings accounts, checking accounts, money market accounts. And you can see that for 2020, we have record levels. And this was as of the end of 2020. So we're 3 or 4 months outdated on this, but it hasn't changed all that much. And people always ask me, hey, Michael, do you think we're in a bubble? Do you think the next crash is coming? And I tend to look at this and I say, well, even if it does come, there's a lot of money that's there on the sidelines that any little dip, we're going to see money flow in, and we're going to see money move from savings accounts to checking accounts and buy on those dips. And that's exactly what we've seen the past year or so. Anytime there's a little dip, we see money come from money that's in a 0%, money market savings account. You know exactly what you have in terms of your savings account. It's not paying that much. So any little dip, we are seeing that. And that's why I don't think we're going to have a huge correction, or we have a huge, 2008, 2009 type period, or going back to 2000 and 2001. We don't necessarily see something like that when you look at the economy right this second. In terms of the actual topic today, tips for preserving your wealth. And what I'm getting ready to say here is very cliche, but one of the ways to preserve and maintain your wealth is to have a long-term time horizon. Now, if you've ever heard a financial planner or really anybody dealing with investments ever open their mouth, they probably mentioned something along those lines. So I get that it's really cliche, But let's look at some data to back up what I mean by that and why that is such a keystone topic when you look at financial planning and really investing in general. And we'll look at the S&P 500, and this dates back all the way to 1937. So 1937 to 2020. Well, if you picked a random day in that period, there's a 53% chance that you have a positive outcome, meaning almost the flip of a coin, that you have more money at the end of the day than you started the day with. So it's not a very good odd. However, your odds go up dramatically the more time you give. So you can see at 1 year, you're at 77%. 5 years, you're all the way up at pushing near 93%. So this is why the more time you give the investments, the higher probability or the more likely you are to have a positive experience. So one way to preserve and maintain your wealth is to have a long-term time frame. And I get that is the most cliche thing, but when you look at the data and you look at the reasons why, I thought it fit really nicely into what we were talking about with Eric today. That was a little update on the market. Talked a little bit about the cash that's on the sidelines, just the large amount of cash that's sitting in savings accounts, checking accounts, money markets, and then again, that practical tip on just increasing the amount of time is a great way to preserve and maintain your wealth. With that, I'm going to kick it over to Eric, and Eric can go ahead and share his screen, and we'll touch on the legal side of preserving and maintaining your wealth, and Eric will shine some light on some tips to help you.
All right. Thank you, Michael. Michael, that demonstrative on the cash on the sidelines was fascinating. I had no idea. I think a lot of people, I talk to people that are saying that, and what you just demonstrated seems to be the case. All right. This is one of the big issues. So asset protection, we talk about that. It is much like insurance. And I actually often get asked by folks where asset protection fits in versus insurance and a way to provide some safety and some security in an environment where people can very easily be sued. We had a situation obviously last year with the pandemic where a lot of people ran into business stress and distress and had a hard time meeting obligations. On a financial side, that opens you up for lawsuits. And all of it comes down to, it really is an issue of timing. I like to use the analogy that if you are out on the highway and you get into a car accident, that is not the time to call your insurance agent and ask about increasing your coverage. It might be a good idea for the future, but it's not going to be of much help for your current situation. Same situation that applies to insurance applies to asset protection, generally speaking, but there are some nuances. An asset protection for, just to kind of put it into simple terms for folks, there's no magic to it. It really is a process of restructuring assets, both your business holdings and your personal financial holdings, legally in a way that minimizes your exposure to creditors in the event something bad happens. That something bad could be a business deal gone south. It could be a business theft that puts you into dire straits in meeting other obligations in your business. It could be something that one of the most common things that I see are folks who get sued for either professional malpractice, such as physicians and other healthcare providers or other financial or professional advisors. Or people who have exposure due to a car accident. And here in Florida, you don't even have to be the driver of the car. I have had several clients, and almost on an ongoing basis, have clients who are being sued because they own a vehicle that oftentimes somebody else was driving, and they get into an accident, and then they find out that the plaintiff's attorney is not going to settle the case without some type of financial disclosure, because they want to find out if the insurance money is all there is to get. Now, with that, I typically do recommend to people, I'm a big proponent of maxing out insurance coverages, um, and protecting yourself in that way. But what you want to do is you want to use that as low-hanging fruit, so you keep everything else that you have, all of your other assets, away from the plaintiff's attorneys, the billboard attorneys of the world, who really just want to take your stuff so they get 40% of it. And there are most definitely there are people out there who are getting excited when they get into a car accident because they think it's their big payday. And what we want to do is we want to make sure that that big payday comes from the insurance company, not from you individually. So we start with the general rule that prior to any type of claim or judgment, and we'll try to talk about what a claim is a little bit later, but generally prior to judgment or prior to any type of financial claim against you, you are free to move assets as you wish. And that is straight from the Supreme Court of the United States. But there's a couple caveats to that. And the main caveat is that what some people will call late stage transfers, these are moving assets after something bad happens, are going to draw scrutiny from courts and from plaintiffs' attorneys, who will seek remedies that are available to unwind what are known as fraudulent transfers. So fraudulent transfers essentially define the boundaries of what we can do in asset protection. As long as you don't have anything bad going on, if you're not being sued or you don't have a judgment against you, you don't have an immediate claim against your assets, you can restructure your personal holdings and your business holdings in a way that is much more protective than what a lot of people do. A simple example would be a rental property. If you have a piece of real estate that you rent out, and you own that in your own name, there's a couple problems with that. One is that if there's a slip and fall on the property, or to use a almost ridiculously extreme example, but a real live example from a client of mine, you have a tenant who has a dog that allegedly bites somebody, and because you own the property, you get sued. That actually happened to a client of mine, and she had to deal with a claim because she owned the property in her own name. That creates liability. Anything that you own that could create potential liabilities, you should consider putting it in some type of limited liability business structure, like an LLC or something similar. On the other side, if you have, let's go back to the car accident example. If you let somebody use your car, or it doesn't have to be a car, it could be a boat. You let somebody, I take an amalgam of real life issues. You let somebody use your boat, that person's driving your boat and they hit somebody and injure another person, you could get sued because you own the boat. You could get sued if you own a car and you lend that out to somebody because they get in an accident with the car. And then you find that you have $100,000 in insurance coverage, but the demand is for $1 million, you now have exposure. On a rental property, if that happens, and you own the rental property in your own name, and you have a car or some type of claim somewhere else, if that rental property is in your own name instead of proper business structure, there's a good chance that somebody can come along and try and take that property as your own personal asset and foreclose on it. Whereas if you had it structured into a multi-member LLC, they'd be limited. The plaintiff would not be able to take that property from you in a foreclosure action. They would be limited to what's called a charging order, which is essentially a lien on distributions if and when made out of the LLC. And as you can imagine, most clients tend not to make a lot of distributions if they've got a charging order against the LLC. Most plaintiffs' attorneys come to realize that pretty quickly, and those types of claims tend to oftentimes settle for very small dollars. Another typical example, again, is the professional, a physician, a surgeon who gets sued in malpractice. Two types of physicians in this world: those who've been sued and those who will be. You have the same issue. You have malpractice insurance coverage up to a certain amount, but you have a plaintiff who is oftentimes looking for their retirement plan, and they haven't worked with somebody smart like Michael over the long term and set a long-term time horizon. Their retirement plan is to take your stuff. There are ways that we can structure holdings of your assets so that doesn't happen. but you can't wait until you've been sued. You have to do it before. And so what we call a reactionary transfer or a fraudulent transfer, this opens the door to potential remedies that lawyers can use through the court system to unwind transfers and sometimes potentially sue third parties for claims that go unsatisfied by whoever the original person was who owed the debt or allegedly owed the debt, and didn't satisfy it and instead tried to transfer their assets away. Typical fraudulent transfer is giving your car to your brother, your Rolex watch to your mom, and gifting everything away. You have money in your bank account, you move it into a sibling's name or a spouse's name. If you do that while there's a judgment outstanding or while you're being sued, you're going to run into problems. This notion of who is a creditor, what I want people to think about is really from this aspect of common sense. If you are moving assets because there is some threat to your assets currently, whether that's a demand letter, a lawsuit, or a judgment, you've got a fraudulent transfer concern. Defining whether a creditor is a present creditor or a future creditor or a possible creditor becomes important in nuances. But what you need to understand is that the reactions are often what get people into trouble. With that said, we'll talk about what is a fraudulent transfer, so you have an idea of that, and then we'll talk about some defenses. So there's essentially two types of fraudulent transfers. There's those that are said to be made with actual intent to hinder or delay or defraud a creditor, and some that are considered constructive. And if I show you an illustration of each one, that'll become clearer on what that means. An actual intent fraudulent transfer is where you make a transfer and there's no real interest. There's no legitimate reason for the transfer other than the fact that you're trying to avoid a creditor, and you meet some of these. It doesn't need to be all. It's sort of a subjective analysis of what was your state of mind when a transfer was made. Did you have a claim against you, and did you make a transfer that left you insolvent? Did you make a transfer and did you conceal it? Did you make a transfer to an insider, somebody like a relative or a business partner? The timing of the transfer, all of these, what we call badges of fraud or indicia of a fraudulent transfer, and can get parties into trouble, again, if you're making a reactionary transfer, if you're doing this after something bad happens, if you're doing this because you had oh my gosh, now I need to do something, it's time to do some asset protection. It's amazing how many calls that I field like that, where people say, okay, I have this issue going on, I need to talk to somebody about asset protection. At that point, it's usually most of what you're able to do, it's too late to do it, but you can plan for the future. And oftentimes we can get away with a scare, and then and it gets people right. Now, versus an actual intent fraudulent transfer, we have ones that are said to be made with constructive intent. And this is really an objective analysis. This is where we basically just look at one factor is whether you make a transfer and you receive reasonably equivalent value. It doesn't have to be equal. We're not doing a full financial analysis here. You may sell or transfer a car because you need cash, and the reality is if you've got a vintage 1977 Nova and you are able to sell that thing, and the best price you can get on Craigslist is $4,000, even if the blue book is $7,000, $4,000 is probably reasonably equivalent transfer or reasonably equivalent value. But if it's something that just looks like it's not right, if you could have sold the asset or if you could have transferred and gotten more value, then you have the first element of a constructive fraudulent transfer. The next element, I'm not going to get too far into the weeds here, but essentially what we look at is what's the effect on the debtor from the transfer. Does it leave the debtor either insolvent or in a position where they are no longer have an ability to meet their obligations? And if you are insolvent by a balance sheet test, or if you are unable to pay your bills as they come due, and you've made a transfer for less than reasonably equivalent value, then you're going to be in a situation where you're looking at a constructive fraudulent transfer. So if you have a fraudulent transfer, that creates, again, I mentioned there's remedies that are available to creditors where they can try to unwind the transfer, and maybe even drag third parties into a lawsuit. Now, I tossed this case up here on the board. This is an interesting question of whether or not the consultation with an asset protection lawyer. So people often ask the question, is asset protection legal? Am I doing anything wrong by engaging in asset protection? The answer to that question is generally no, but we like to combine asset protection planning with estate planning, with corporate restructuring, with a full analysis. You might go through, maybe you got married or you had a life change, you had children. People start looking at their insurance situation, they start looking at their retirement situation, their financial situation in general. Maybe you're starting a business, and you're also going to engage in some type of maybe transfers and changes in the way you hold assets to protect yourself. And you may engage somebody who practices in the area of asset protection, as our firm does. But if you are subject to a lawsuit judgment, and one of your reactions to the judgment is to engage the services of a firm that is held out as being an asset protection law firm, this is actually a factor that some courts have looked at to essentially suggest, through these badges of fraud that I mentioned earlier, that that's one factor to look at on whether or not a transfer is a fraudulent transfer to be avoided. Does that mean you shouldn't consult with an attorney? Absolutely not. It just means that, again, it's the emphasis on how courts look at this before and after something bad happens. Having said that, I will tell you that I talk to several folks very often who have something bad happen and then come consult with me, and through protections they may not even realize they have in place. When I did one of these previously, and I had the good fortune to join Michael on one of these calls, we talked about some things that people can do themselves without an attorney to protect yourself. And that's things like taking advantage of our homestead protection, taking advantage of statutory exemptions, 529 accounts, IRAs, and 401k accounts, and other types of retirement instruments. These are statutorily protected generally. Some wages for the head of household are protected by statute. So just because something bad happens and you haven't actively gone through the process of engaging with asset protection counsel or trying to do some things yourself, doesn't mean that you're not protected, and you shouldn't consult with somebody to see what exemptions and what type of protections are available. You can also use that for negotiating leverage when you're working against a plaintiff's attorney who's trying to marshal up as many assets as possible. It's amazing how often I talk to clients, and as we go through their assets and figure out what they have, we realize that most of the stuff is either protected or is protectable through legitimate mechanisms where we don't have to engage in fraudulent transfers. It's always that fraudulent transfer that gets people in trouble and really creates a lot of problems. What are some of the ways we can avoid a fraudulent transfer claim or defeat a fraudulent transfer claim? Something I like to call a legitimate supervening purpose. I'll take, for instance, one case. This is from a reported case in Florida where somebody was subject to a big judgment as a guarantor of a loan with several other folks on a real estate project that went bad back in the early 2000s, as a lot did here in Florida. There was about a $7 million judgment entered, and this person set up an offshore trust for the benefit of a child with a couple $1 million in it. But he was able to show the court that the child had just been born. The child was apparently born with a disability. He was worried about future medical care for the child. He had some assets. He had been speaking with people about planning for long-term care for the child over a long period of time. There were also reasons he thought that he wouldn't have full responsibility for the judgment. And so there were some great arguments that were made in this subjective analysis on whether or not he had engaged in a fraudulent transfer, where a court ultimately ruled that he did not and protected his transfers. Again, I mentioned statutory exemptions, and the nice thing with homestead here, if you qualify with a homestead, and it's not hard in Florida, but there's acreage limitations if you're within a municipality. If you're outside a municipality, something as large as a farm or a mobile home park could be protected, as could a multi-tenant property sometimes. I've seen duplexes and triplexes be protected as homesteads, as long as they meet all the other criteria. On the other side of a business on the first floor and an apartment on the second floor might protect the entire property if it's a homestead property. But there was a case out of Daytona where an individual had an apartment building that was also on the first floor was a strip club that did not qualify as a homestead. So there are limits even where that's concerned. But with a homestead, the nice thing there is that uh, even if you make a transfer and you purchase a homestead or you buy a bigger home or you improve your homestead or you pay off your mortgage after a judgment has been entered and it would otherwise be a fraudulent transfer, the Florida courts, the Florida Supreme Court have said that that is not a fraudulent transfer because the homestead statute trumps the fraudulent or the homestead constitutional protection rather, because it is a constitutional protection of Florida, trumps the homestead statute. And you can in fact buy a homestead, upgrade your homestead, make improvements, pay off a mortgage, and do other things to improve your homestead as long as it qualifies, and it will not be considered a fraudulent transfer. That can be a very powerful tool in negotiations. Uh, so we think about how we can incorporate that with some of these other exemptions, even if we're representing somebody who hasn't previously planned and has issues. There's different approaches. We use things like valuation issues. I wrote an article about this. I won't go into a lot of detail on it right now, but we did an article for the Florida Bar Journal a couple of years ago. And if you're interested, I'm happy to circulate that. Essentially, what we do is we take a look at what the value of an asset is today and what the value of an asset of a liability is today. And we compare that over a time horizon to see if at the time of a transfer, there actually was a fraudulent transfer. So a simple example is I had a client a few years ago who had bought a property in the real estate boom and refinanced the property. And at the time he purchased it, it was about $900,000. And a couple of years later, that property was only worth about $20,000. And he went through a foreclosure lawsuit on that property. And during the time he was going through a foreclosure lawsuit, he made a couple other transfers, and the attorney on the other side wanted to argue that those were fraudulent transfers. And my response was that because he had a property that he purchased using a loan from the plaintiff for almost $900,000, and the property was presumably worth that much, there should have been enough value in the property to foreclose, use the property to cover the judgment. We didn't have a fraudulent transfer concern. He wasn't going to need his other assets that he properly planned with. That combines with what you see here, the nest egg approach, which is even if you have a claim against you or you have liabilities, as long as you account for those liabilities, you can take the rest of your nest egg, so to speak, and put that away. You're essentially taking chips off the table. If you've got, let's say you owe $500,000 in liabilities, but you have $1.5 million to work with, then you can take $1 million and you can do something else with it without having a fraudulent transfer concern, even if there would otherwise be a claim outstanding, because you're not running into a situation where you're not able to pay your debts as they come due. You're not going to be insolvent. There's also statute of limitations, which gets very tricky in Florida. And I have seen several cases where the statute of limitations gets blown on a fraudulent transfer claim. So again, something else, we always think about, what type of defenses, if we're in that situation where somebody has already either has moved assets or is about to move assets, we don't want to move anything. We'd prefer to do the analysis ahead of time and figure out what we can move that's not a fraudulent transfer and not get us in trouble. But even if we have a fraudulent transfer concern, there's several defenses to it. I just tossed this up here. If you have either engaged in any corporate structuring, personal structuring that involves some asset protection work, if you have been subject to a judgment and you have moved assets around and you think you've hidden stuff, bankruptcy is to be avoided. Bankruptcy rules are totally in as far as asset protection and asset acquisitions go, totally separate from our regular court system, because the bankruptcy courts, they will just change rules. Lots of folks are familiar with the notion now that a single member LLC is not very protective in Florida and many other states, because The courts now allow foreclosure of the single member LLC. Who do we have to thank for that? The first case was a bankruptcy court case in Colorado in Ray Albright. We have seen cases such as the Tully case, where some folks, it was a debtor, somebody who owed money, and her significant other moved from California to Florida, sent emails to again, an asset protection attorney, asking about offshore trusts and other ways to protect assets after a judgment was entered. And then one of the folks filed for bankruptcy protection. All of the email communications with the attorney ended up being exposed. How does that happen when you have attorney-client privilege? First, the debtor who filed for bankruptcy, when you file for bankruptcy, you come clean with everything you have, and you're turning over your assets to the trustee. And the trustee now takes control of your assets to distribute them for the benefit of your bankruptcy estate. Well, one of the assets that the trustee argued they should control is the communications with the attorney. And they were successful in that argument. They were also successful in a second argument, which was the crime fraud exception that allows disclosure of attorney-client communications. But the bigger issue here is that the trustee was able to take over that communication with the attorney by virtue of the fact that the debtor had filed for bankruptcy. Now, what about the significant other? That person did not file for bankruptcy. Why did they lose the attorney-client privilege? Well, that's because they engage the same attorney, and you have a joint defense doctrine that essentially says where you have an attorney who represents more than one party to the representation is entitled to the communication that goes on with all the other parties in a similar or related transaction or engagement. So here you had one attorney representing two different people with regard to the same assets and some of the same issues. And so when the bankruptcy trustee stepped into the shoes of the first debtor defendant, in that person's shoes, they were entitled to the communications from the attorney to the other client. A totally disastrous result that really made everybody look bad in that case. Stay out of bankruptcy. Professionals, we have, I'm sure, Michael invites us on here and we get other attorneys, financial advisors, accountants, bankers, professional advisors who may get asked about setting up accounts and helping people avoid judgments. Not a good idea. We have had tested here in Florida civil liability against the professional advisors. A lawyer was sued, a banker, a financial advisor. And in Florida so far, the defenses, and I know some of the attorneys who've been involved in these cases, the defenses have been successful to say that there's no cause of action against the advisor who helped somebody who was involved in a fraudulent transfer. But other jurisdictions have not been as kind. We've seen liability in other states, such as in New Jersey, New York, California, Kentucky, Illinois. It's a state-by-state issue, but we did have a federal U.S. Supreme Court case a couple of years ago, and I did not like the language from this case. It was this Husky case. If anybody's interested, it's short. I can send it to you. It was decided after Justice Scalia had passed away and before the 9th justice was appointed. So it was an 8-justice decision, 7-1, where the bankruptcy court essentially said that a fraudulent transfer is the same thing as fraud, and allowed conspiracy, or opened the door rather, for the notion of a co-conspirator or conspiracy liability against other defendants as a result of a fraudulent transfer. So again, timing is huge on this. This is all to say that the time to do your planning, just like your retirement planning, your financial planning with Michael, the time to do this stuff is not at the last minute. It's not at the end of the day. It's early in the day when the skies are sunny and things are looking good. Please keep this stuff in mind.